back to the 2025 relaunch of our October Lunch and Learn. We're going to get better with these, I promise, but I thank you so much for sticking by us. This month is on felonies. What we want to talk about first, the thing that we talk about before we do any kind of training, is what are the policies that I use? So we have an effective date for policies. Even though we're looking at the calendar and we're seeing that today is October 23rd, 2025, that is not necessarily the current date of the guidelines that you're using. So the way that we define current with respect to the guidelines is the guidelines in effect when the current offense occurred. So just the other day, I helped someone with a 1994 guidelines, and we had to go back to the 93 book because it happened before August. Guidelines are in effect August 1st through July 31st of the following year. We did have a switch in 2021 where they were in effect September 15th through July 31st of the following year. So watch out for those, but otherwise that's a pretty consistent, it goes right in line with all the new laws and everything. So that has remained a consistent date. You're going to want to use those current guidelines to find everything related to the current offense, meaning you'll find the severity level, modifiers, any mandatory minimums, and then the grid that you'll use to find the presumptive sentence. But after 2019, we had a slight change to how we calculate criminal history. There was a decision called the Robinette decision. That was the name of the defendant who appealed his sentence. And basically what ended up happening, the very, very short of the very long story, is the Supreme Court determined that the guidelines had to apply the amelioration doctrine, which means if there's a policy or a law that is meant to mitigate punishment, it goes into effect regardless of the offense date. So what that means now is after 2019, you only need to use one book, the manual that is in effect when the current offense occurred. But because we did not go back and redo all of the previous manuals, you may have to go back to the manual to find the policies, knowing that you will use what went into effect in 2019 for criminal history. And it affects things like custody status, a half point versus a full point, waiver of the custody, the type of custody that you can have, and decay factors. So we're going to see Robinette applied today through the decay factors, which changed. But I did put a little table up there to show you, based on what your offense date is, which manual should you use for criminal history versus which manual do you use for everything else. So again, if there's ever an issue of which manual should I use, don't hesitate to reach out. We can let you know. We don't anymore. We're not going to need you to have copies of those because we have them on our website. So our web address is mn.gov/sentencing-guidelines. And if I were you, I would bookmark it because this is your magic website for everything guidelines related. But with this, the previous guidelines, you just select the guidelines option, go to Sentencing Guidelines Archive, and then you can select what date you need. You can sort them newest to oldest or vice versa. They go all the way back to May 1st of 1980 when the guidelines went into effect. So we want to eliminate the idea that, well, I don't have a copy of that book. You don't need a copy of that book because we have it right here for you. That's also where you'll find any of the modifications or amendments that happened that year. as well as the grids that are in effect at that time. When we talk about criminal history, we're really using this concept of the level of sentence to determine where something's going to go in criminal history. So since we're working with felonies on this webinar, I'm only going to talk about those. In Minnesota, we have something called the imposed sentence. And that's not indicative of whether they go to prison or jail or are put on probation. The imposed sentence is actually how we define the duration of the sentence that the person receives as it is reflected in statute. So for felonies, 609.02 subdivision 2 is the statute that tells us the minimum duration to impose for a felony level of felony level offense, there you go, so that it will remain a felony in criminal history. So if the felony was sentenced before July 1st of 2023, so on or before June 30th of 2023, felonies got 366 days. After July 1st, on or after July 1st of 2023, felonies got 365 days. So sometimes when you're trying to determine where an offense goes and you see that they got a sentence of 365 days, you're going to want to pause and see when was that sentence imposed. Because if it was imposed before that date change or that duration change in July of 2023, that 365 days makes that a gross misdemeanor, which we will talk about in that training. But in this training, we're looking at just felonies. So again, 366, 365, depending on when it was sentenced. So that's what an imposed sentence means. It's the duration, which can either then be a stay of execution or it can be a commit to prison. But if it is a non-Minnesota felony, and I'm going to mention non-Minnesota offenses or out-of-state offenses a couple of times here, but we're not going to go in depth because we do have a training specifically for that coming up. I just want to point out that in order for an out-of-state offense to equate to a felony, the imposed duration still remains at 366 days or a year and a day, regardless of the sentencing date of that prior offense. So because we have something called an imposed sentence, that tells us exactly what the level of offense is, or excuse me, the level of sentence is based on the duration imposed. But what do we do if that imposition is stayed? So in Minnesota, a defendant can get a stay of imposition on a sentence as a sentence, which means the court is not going to impose a duration that aligns with statute. So there's not a 366 days or 180 days or 45 days, nothing like that. So whatever happens to that when it is a stay of imposition, it means it's going to stay at the conviction offense level. So a felony is used as a felony in criminal history. It's important to note that stays of imposition will eventually become misdemeanor level sentences based on a successful completion of probation. But that is only for non-criminal or civil purposes, like a job application or a housing application, where they can say, if they successfully complete it, that they've never been convicted of a felony. But until it is successfully completed, it remains a felony. And even if it is successfully completed, a new crime causes that to be reflected in the felony level section. And we do have a term that we run into frequently with a non-Minnesota offense. It equates to a stay of imposition because there was a conviction or an adjudication of guilt, but only a probation term pronounced. So not just a guilty plea, but an actual conviction or adjudication of guilt that they received for that 366 days. And we sometimes see that called sentence withheld. I know that's the term they use in Wisconsin, sentence withheld. So just as a tip, when we have a stay of execution, that just has something to do with how the sentence will be carried out. Will it go to jail? Will it be prison? Or will it be a stayed sentence that they serve probation for? Versus a stay of imposition means we have no duration whatsoever that is imposed. So those are the two differences. And we don't want to look at probation terms or jail time as a condition of probation, relating it to the level of sentence. We're looking solely at that imposed duration. But you may run into a situation where you have a defendant who has what I have termed, for the purposes of training only, is a non-conviction disposition. And the reason why I call it a non-conviction disposition is because there might be a guilty plea. We know that if you're going to get a 152.18 stay of adjudication, that there is a guilty plea. But the court is not going to enter a judgment of guilt, meaning there's no final judgment, adjudication of guilt, and no conviction. And with no conviction, we can't have a sentence. So we can certainly have a conviction and no sentence imposed, but it can't go the other way around. No conviction, but a sentence imposed. So whenever we see a stay of adjudication or a continuance for dismissal, those are not going to go in felony history unless they are revoked prior to sentencing on the current offense and they receive an imposed sentence, including a stay of imposition. So a non-conviction disposition will become much more important when we do custody next month. But for now, you can cross those off for inclusion in the felony section unless there is that revocation. And an important thing to point out here too is when that is revoked and a sentence is imposed, that is technically the first time this person is receiving an imposed sentence, which means there should be an updated worksheet to include any offenses that they have picked up in the meantime. So don't treat that as it was when the offense was disposed. Treat it like it should be when it's revoked, and it's like the first time they're being sentenced on it. Another thing that we have to consider with respect to felony criminal history is, what do we do with fifth-degree controlled substances after the decision State v. Strobel? So we usually refer to this as applying Strobel. Like, did you apply Strobel? Did you meet Strobel? Things like that. So we're talking about when the current felony offense, any felony offense, occurs on or after August 1st of 2016. There are three questions that we need to ask with respect to the first eligible felony fifth degree that you're considering for criminal history. So that's the one we're applying Strobel to. So the first question that we ask is, did the prior fifth-degree offense occur on or after August 1st of 2016? We're asking that because only the disposition date shows up on the worksheet. So did it occur before then? And if it did, did it occur after August 1st of 2016? Because if it did, we know that we can include it in the felony section because we have to assume that it was charged as it was intended after the drug laws changed, and you're done. You've applied Strobel. But if the answer is no, we have to go down to the next question and ask, was it a prior felony marijuana or was it sale? And we asked that because the 2016 laws did not have any effect on sale offenses or on marijuana offenses. So I know that there are law changes to marijuana, and I applaud you if you understand them because I am still finding my way through them. We can work together on them. So right now, I'm just focused on Strobel. Because if it was if it was prior to 2016 and it was a marijuana offense, we only had felony. So if you answer yes to those questions, you're done. You've applied Strobel. But if not, you have to go down to the third question, which is, does the defendant have a prior drug conviction that was sentenced prior to the current offense happening? So you have conviction, sentence of the prior, and then the new offense occurred. So we have a true prior. If that's true, then according to the statute, that cannot be a gross misdemeanor. Under the statute, having a prior has negates the weight of the offense, the weight of the drug, excuse me, and it makes it an automatic felony, if you will. So what we're looking at there for that prior conviction is from Minnesota or any other jurisdiction, does it equate to a Chapter 152 offense? And that includes offenses that are decayed or were petty offenses. Those also count because when you have a petty offense that you plead guilty to, you get convicted of it. So therefore, you have that prior conviction. If you answer yes to that, you've met Strobel. But if you answer no to that, then it has to go into the misdemeanor, gross misdemeanor section of history, unless the prosecutor in the current case is going to say that that prior was not a trace case. So that means it was not 0.05 grams of heroin or 0.25 grams of a non-heroin. And if I could just ask everybody to quickly make sure that they're still on mute because we hear some talking. Thank you. So you're going to include that in the misdemeanor or gross misdemeanor section unless the prosecutor in the current offense says, no, that's a felony. Hey guys, check your mute microphone. Thank you.
Record a few seconds before you're done and after.
Devontae, can you see who's not muted?
Yeah.
It's really disruptive for everybody who's trying to listen in. All right. So you can see that as soon as you answer yes, you're done. But if you keep answering no, then you've got to turn to the prosecutor because we, meaning the guidelines, the commission, but also the Supreme Court who decided this case, it's not for the probation agent to be the fact finder in the case. It is for the prosecutor. So now we'll talk about what will actually go into felony criminal history. And that issue of level of sentence and the issue of meeting Strobel, those are things that we use to determine eligibility of an offense to be used in criminal history. So what we're talking here is everything that has met the eligibility test. And now we're going to use that in criminal history. So the eligibility test has been met for all Minnesota felonies that received an imposed sentence before sentencing on the current offense. So we don't need to worry about whether or not the offense occurred before the current offense. It can occur after, as long as it was sentenced before the current offense. So again, if the sentence was before July 1st of 2023, it's a 366-day sentence that gets imposed. After that date, it's a minimum of 365 days. A non-Minnesota felony will remain at 366 days to stay a felony in criminal history. And again, the January session is going to talk about, it's probably mostly going to talk about non-Minnesota offenses. So hang tight, but again, remember, in the meantime, we're here for you. It also includes any Minnesota or non-Minnesota offenses that received a stay of imposition, which may be referred to in other jurisdictions as a sentence withheld. And it's also going to include all EJJs. EJJs are considered felonies under the guidelines because they're a conviction. So while they are under that EJJ, that's the place where you'll actually be able to use a JV court case number in the electronic worksheet system. But if it's revoked and it gets a CR case number because they've executed that EJJ sentence, then the only one that you want to put in is the CR case number. So it's not both of them. It's one or the other, depending on what the status is. So those are the types of felonies. So if it qualifies here, it's going to go in criminal history, provided that it's not too old. And so we have a start date and an end date with respect to counting criminal history and the decay. The end date is always going to be the same. The end date is always going to be the date the current offense occurred. So felony priors are going to remain in criminal history for 15 years from the starting date to the date the current offense occurs. And it's that starting date that can be, I don't want to use the term flexible, but it can be an either or kind of situation. So the starting date is either going to be the disposition or sentencing date of the offense when it was probation. So they got a stay of execution or they got a stay of imposition, and it was never revoked. Then the starting date is going to be that sentencing date to the date the current offense occurred. If, however, it was a prison sentence, so whether it started as a prison sentence or it was revoked and they went to prison, now the starting date that we use is going to be whatever date the end of that prison sentence was. And that includes all the components of a prison sentence. So the term of imprisonment while they're in the facility, the supervised release where they're out in the community, and any conditional release if that is applicable. If they get a stay of adjudication, however, that is later revoked and given a new imposed sentence, when you're using those in criminal history, now you want to use that new starting date for the decay. So the date they moved from the stay of adjudication over to the stay of imposition or stay of execution. But if there is a revocation on a stayed sentence, and maybe it's going from a stay of imposition to a stay of execution, that stay of imposition is the original sentence. So there's no need to do an updated date on that. If it's an EJJ, again, use the date that they received that EJJ as the starting date. So 15 years from the established starting date to the date the current offense occurred will be how we determine what to include. But offenses that are still under custody will not decay. So for those of you that work in the electronic worksheet system, these are the two questions that you have to answer on each of the felonies that you put in. The first one shows us that never executed probation sentence where we said no on the felony, that they did not go to prison, and no, they were not under custody. So it shows us the disposition date up through when the current offense will decay in 2026 for that one. Versus on the right side for an executed prison sentence where we answer yes to the prison term question, now it's going to point it to the expiration date. And if we had selected yes on either one of those for the custody question, it would tell us that the offense will not decay while it's still under custody. That is an interesting thing that you can encounter when someone is on warrant status for an offense. And we will talk a lot more about how custody applies to warrant status offenses next month. But just know that the clock starts ticking. So technically, even if it's been 10 years, and it would have expired 10 years ago, but they still haven't been picked up, they're still under custody for it. So that on warrant status can really change the decay for something. Next, steps for equating felony severity levels to points. So the two simple steps. Step number one, what grid is the current offense being sentenced off of? The standard grid, the sex offender grid, or the drug grid, because there are different point values depending on what the current offense is and what the prior offense is. But the second and most important thing when dealing with priors is you use the guidelines in effect when the current offense occurs to find the severity level for all prior offenses. You do not go back to the guidelines that were in effect when the prior occurred. That dealt with it then when it was sentenced. So if you have a prior from 2016 that you're trying to equate as a prior for an offense that was committed in 2024, you either use the 2024 or the 2025 guidelines, depending on whether or not it was before or after August. So you always pull everything forward into the new book. But I want to give you some reminders based on that. And the first one would be offenses that are now found on the sex offender grid, which went into effect in 2006, used to be on the standard grid. This was the first breakaway grid. So up until then, we only had a standard grid, and the only change really to that as far as severity levels was changing them from Roman numerals to numerical severity levels. But if you have one that's old enough to have either a Roman numeral or another, a number, wow, there we go. you're still going to want to pull it into what the current severity level is if your current offense happened on or after August 1st of 2006. So criminal sexual conduct in the first degree could have been a 7, it could have been an 8, or it could have been a 9, depending on when it happened. Those are all B's, those are all A's now. You might have a severity level 6 for a prior CSC2. Will that be a B? Will that be a D? It depends on the statute. So you really want to look at the statute and equate that to the new severity level. Don't worry too much about what it might have been in the past. Again, what is it now? Now being the date the current offense occurred. This happens also with the drug offender grid, which was the next breakaway grid in 2016. And here we went from just a number to a number letter combination. So we had a D something. So a 5th degree drug that was a severity level 2 is now a D2. A severity level 8 for a 2nd degree is now a D7. And just as a spoiler alert for next month's custody training, we're going to learn how that change from an 8 to a D7 can have a big effect on whether or not a custody can be waived. So, spoiler alert, but stay tuned. Prior failure to registers may have been sentenced at a severity level H, but now that's a severity level I under the 2021 guidelines. If there's an unranked offense that was ranked, that has not yet been ranked by the commission, then use the severity level assigned when it was originally sentenced. But if an unranked offense has since been ranked by the commission, now you want to use that one, even if it's different from the one when it was originally sentenced. So labor trafficking is a great example. That is now a severity level 7 if the current offense happens on or after August of 2023. So even though that might have gotten a 2 before, it's a 7 now. Another common one, if I could just pontificate for a second, is machine gun. That used to be a severity level 3, and now that is a severity level 8. So sometimes even something that was assigned by the commission can change within the scope and the nature of what happens to that offense with the legislature. And so machine guns went from a 3 to an 8, which means machine guns went from being worth 1 point to a 1.5. So these are the felony weight tables that are found in section 2B.1a and 2B.1b. The first one we'll talk about is a current offense sentenced from the standard grid or the drug grid, which means not on the sex offender grid. So you look at this table to determine the weights. So you can see how a severity level 3 through 5 is worth 1 point, but a severity level 6 through 8 is worth a 1.5. So that is an example of how that machine gun offense can change from when it was originally sentenced. And then there are points assigned to both the drug grid and the sex offender grid based on, it very similar to how they used to be, but now under that new severity level. With a severity level H, if you have a failure to register and the current offense is before 2016, wow. If you have a failure to register in criminal history and the current offense occurred before 2021, September 15th of 2021, it will be an H. After September 15th, 2021, it will be an I, but we still treat it exactly the same. We give a half a point for the first offense listed in criminal history and a full point for any subsequent offenses, not offenses that were charged as subsequents, but second, third, fourth, fifth, etc. in criminal history. Assigning felony weights when the current offense is found on the sex offender grid means you're assigning a letter as the current offense severity level. Most of the severity to point values remain the same, but criminal sexual conduct in the first degree and criminal sexual conduct in the second or third degree under certain statutes that are B's and C's will both go up. They went from a 2 for first degree crim sex to a 3. And I think where we see the most errors here is not remembering that failure to register as a predatory offender is found on the sex offender grid. So even if the registration does not stem from a criminal sexual conduct offense, it's on this grid for now. And so that's why we want to make certain to equate any prior criminal sexual conduct or other sex offenses found on that grid to their appropriate severity level. Next, Hernandizing. So this is assigning weights when you have current multiple offenses that are sentenced before the same court at the same time, sentenced in the order that they occurred. And as each offense is sentenced, it's eligible to be carried over into criminal history on the next offense. We all know that to be Hernandizing. Hernandizing is just simply the idea that the court is being what it was, is practicing judicial economy. And instead of scheduling 3 or 4 or 5 different hearings, they're just going to do it all in one day, which means ultimately the Hernandez case, which is where this comes from, just simply defined that first sentence of 2.B.1 that says, include everything that received an imposed sentence or stay of imposition or was an EJJ conviction sentenced before sentencing on the current offense. Sentenced before the current offense is sentenced. That's all Hernandizing is. So we want to sort of take away the mystique from it and just realize that if you have a sentence number 2, you're going to probably, and that's the emphasis on the probably, Hernandize. But I want to say more often than not, you're going to Hernandize because we do have 2 exceptions to this policy. But I think as we look at the exceptions, you'll realize they're exceptions for a reason. And if they don't exist, we simply Hernandize. So we have this first person, Mr. Sample, being sentenced on this aggravated robbery. And now they're going to receive a sentence on this felon in possession. And we're going to Hernandize that. We're going to put the aggravated robbery onto that felon in possession. And then within the same hearing, the court is going to finalize a sentence for this 5th degree drug offense. And therefore, we're going to put the aggravated robbery and the felon in possession onto criminal history for the 5th degree controlled substance. And if you're using the EWS system and you have that copy priors from prior worksheets, when you copy the prior from this 5th degree drug, it will put in all of that criminal history, the juvenile, misdemeanor, gross misdemeanor, felony that exists, as well as the current offense will carry over as a prior. So again, Hernandizing is pretty much what we're going to do most often when we have an offense, when we have, multiple offenses sentenced on the same day, in the same hearing, same judge, same everything, except if we have a single course of conduct, multiple sentences. Don't let the title of this policy dictate your perception of it. A single course of conduct, multiple sentences is very specific to what offenses those multiple sentences are imposed for. When the offenses occur, when multiple offenses, occur as a result of a meth offense involving a child or a vulnerable adult, a burglary, or a kidnapping, plus additional offense. So a burglary and a theft, or a kidnapping and a crim sex, manufacture meth involving a child or a vulnerable adult. Because this double jeopardy policy and statute exists, the way the commission because the double jeopardy statute exists, the commission policy reflects that by saying conviction of, for example, a burglary is not a bar to conviction for anything else that occurs as a result of the burglary. So you can get 2 sentences there, but no Hernandizing. So we're not going to use the earlier or first offense sentenced on criminal history for the later offense, the second offense. And when this event is considered as criminal history, we have a different way of looking at it, where we only take one of the offenses at their highest severity level. So again, single course of conduct, multiple sentences sounds as though that previous worksheet we looked at should not have been Hernandized. But it was because the offenses were not meth, that special meth offense, a burglary, or a kidnapping. And there is a comment in 2B.109 that I want to point out. And this was a gentleman that appealed his case because he was Hernandized for an offense that is found in 609035, subdivision 3, parent 6. Subdivision 3 is felon in possession, and it reads the same way. A conviction for this offense is not a bar to conviction for any other offense that occurs as a result, which is why we were able to Hernandize the previous aggravated robbery and felon in possession. We could Hernandize the robbery onto the felon in possession because the commission looked at that case and said, you know what? We're going to stick with what we have. So even though there may be case law, this was a time when their commission said, we're going to keep this solely related to burglary, kidnapping, and that meth offense involving children or vulnerable adults. So that's the only time you don't Hernandize. So when we do a worksheet for those, you can see we have a burglary. On the left, we have a second-degree burglary of a pharmacy. And on the right, we have a theft. In the future, on an unrelated offense, and by future here, we have sentence number 3. But this is an offense that occurred about a year later. It's also being dealt with at this same hearing. we're only going to carry over the burglary, the second-degree burglary, into criminal history because that's the one at the highest severity level. But what this person did was they made a line that said burglary second degree pharmacy / theft of a controlled substance. So by putting those both on a single line, it demonstrates why those two priors became one listed in criminal history. So again, no Hernandizing when it's the current situation, only carrying one at the highest severity level when it's a prior situation. Next, we have a single course of conduct with multiple victims. This is sometimes difficult to discern. Is this a victim offense or not a victim offense? So I'm feeling like that would be much more of a legal decision. So we really, when we're teaching this, we talk about things like aggravated robbery, criminal vehicular operation or homicide, those types of situations where one single event created multiple victims. So in that situation, multiple sentences can be imposed based on the configuration of, are these lesser included? Are they eligible to be sentenced? All of that stuff gets figured out before this policy steps in. So once you have what is left over and the sentences that will be imposed, again, the exception is not to the number of sentences that can be imposed, but to the number of sentences, that can be Hernandized. And when we're doing these, we Hernandize only 2 at the highest severity level as we move through the offenses. And when we're putting these in criminal history on a future unrelated offense, we're going to take 2 at the highest severity level from the entire incident. So when you have 5 sentences in a single hearing, you only have 4 to look back at. But when you have that next unrelated offense, you have all 5 that you can look at. So in practice, that would appear as an aggravated robbery, a second aggravated robbery, which we Hernandize, and a third aggravated robbery, which we have Hernandized. So you can see that as we build through these worksheets, it sort of looks like normal Hernandizing, where we just keep carrying the next one over onto the next imposed sentence. So it's when we get to sentence number 4 that we actually see the policy take effect. So not only do they come in with the criminal history they started with, but we're only adding 2 of them. So you can see on those 2 worksheets, he's got 4 felony priors on sentence number 3 and 4 felony priors on sentence number 4. And he'd have 4 on sentence 5 and 4 on sentence 6. It would just go on. The priors might change depending on the severity level and how that went through, but ultimately the number of priors will be consistent. And then when we get that last unrelated offense being sentenced, here's sentence number 5, we're going to look back at those previous 4, pull the 2 at the highest severity level. These are all aggravated robberies, so it makes it easy. And it just carries 2 over. And my tip for those of you that work with the electronic worksheet system is go through, keep Hernandizing, keep building the criminal history, and then go back when you're completely done with the worksheets and remove the ones that are not applicable. it just makes life a little bit easier, and deleting is a lot easier than manually re-entering. So get everything in there and then go back and just sort out what needs to be deleted. There are a few other policies within the felony section that I wanted to go over with you. The first one, whenever a felony is sentenced with any type of modifier, like an attempt or a subsequent, anything, that's about the sentence that gets imposed at the time that offense is dealt with. But in the future, we're still going to assign the full severity level to it. Even though it might have been attempted aggravated robbery, the sentence would have been cut in half originally, but we're still going to leave that at a severity level 8 in all of the future worksheets. 2B.1 specifically says to include everything that receives an imposed sentence or stay of imposition or is an EJJ conviction, which means those offenses where there is a conviction only and no sentence imposed, those do not go into criminal history at all. Next, when a felony is sentenced to less than a felony duration, it's used in the misdemeanor, gross misdemeanor section. And it's very important to remember that sentencing an offense, a felony, to less than a felony duration makes it that level. So if a sentence is given for 180 days on a threats of violence, that's now a gross misdemeanor threats of violence. But a stay of imposition remains at the felony level. So remember that this policy, 2B1H, is applied to imposed sentences. Again, we want to take a look at the sentencing date, because if it was before July 1st of 2023 and they got 365 days or less, that's not a felony. But it's after July 1st of 2023, they get 364 days or less because of that changeover on July 1st of 23 from 366 to 365 and 365 to 364. But most importantly, this policy does not apply to stays of imposition. And finally, the one that we're pretty familiar with after a bit of a debacle with the custody status, whenever we have a half point in the felony section, that's always going to round down at the end to become a whole number. So 2.5 becomes 2, etc. So that brings us to the end of today's felony presentation. Thank you all for joining us for